You are what you do. You can say any amount of things that you want to say, but what you do is what everybody sees.
People are like, "Oh, I'm just going to JV it." Like, let's just JV it. Like, what the hell does that mean?
I cannot tell you how excited I am to hang out with you guys today. So thank you so much.
Well, then that end buyer could come back and say, well, I didn't fully understand that it was subject to.
That's not a thing. Like, the SEC has thought of all of these things. They've been here since 1932.
And you can do what you want with your property.
Buyers have time, they have negotiating power, they have options.
Oh my gosh, I am blown away by your inexperience, and they've been in business 20 years.
And that includes things other people put on your property, right? It's your property that'll be okay. Suddenly, Cousin Jimmy's in a lawsuit.
A novation is replacing one contract or one obligation with another.
Out with the old, in with the new.
Yes.
Hey everybody, welcome to the show. Today our topic is removing clouds on title to real property. I'm Andy Fowler and I'm here with Sean St. Clair. If you're new to the show, make sure to like and subscribe to our channels. You can find us on Facebook, you can find us on YouTube, and you can also find us on Twitter. On YouTube, we are at NREM Podcast. That is at NREM Podcast. With that, I'm going to turn it over to Sean, who has our legal update.
Thank you, Andy. So the legal update for today is, can an investor complete a subject to transaction when the owner of the property is deceased and a probate proceeding is pending? Meaning the owner has died, a personal representative in Arizona or other states sometimes call them executors has been appointed. There's a proceeding taking place in the probate court, and the property is one of the assets of that proceeding. Can an investor then come in and say, look, I want to purchase the property subject to the existing loans on the property? So a couple of points to make on that. So number one, remember the personal representative is not the person that's going to inherit the property. There will be other individuals generally who will inherit. Sometimes it is the personal representative. Sometimes they're going to receive it all. But normally you're going to have the personal representative may inherit some, and then you're going to have other heirs that are going to inherit the property. So what that normally means is that if you want to purchase that property subject to the existing loans, the personal representative and the personal representative's attorney is generally not going to be comfortable with the idea of them just signing off on the transaction if there are other heirs that are out there who may object to the transaction, to the subject to transaction. Because remember, the heirs, you know, in some ways this is found money or found assets. So they may be like, well, I just want to be cashed out. You know, I don't want to have payments come in on a regular basis or anything like that. But on the flip side, they may look at it and say, okay, well, I might be able to sell it a little bit more if we do some level of, seller carryback financing. We keep the existing loans in place because maybe the property needs a lot of work. And to sell it in cash and its as is condition, you're not going to get very much for the property versus if you do more of a creative type transaction, you might get more for the property, except your payment's just going to be made over time. So normally if there's other heirs in place, the personal representative may be intrigued by the transaction, may be interested in doing it, but they're going to have to go and obtain either the approval from the other heirs to do it that way, or they're going to have to go into probate court and seek the approval of the court and lay out the nature of the transaction to the court and explain why they're doing that. And then the court would have to approve it. Then what would happen is once the transaction is fully consummated and escrow closes, the personal representative does have the ability, then the asset isn't the property because the property has been sold. The asset then held by the estate is the carryback financing note that's executed by the buyer in favor of the estate, the seller. And then they are going to distribute and assign that promissory note to the heirs, who will each have some ownership percentage in the promissory note and in the payments that are being made. So normally you're going to want to have, say, a servicing agent that's appointed to collect the payments so that they can properly distribute them according to who has, whatever percentage of interest in that promissory note. So I say all that to say it can be done. It's just there's some extra steps involved, and you're going to have to basically convince maybe more than just one person run party, i.e. more than just the personal representative. You're probably going to have to convince the other heirs why it makes financial sense for them to do that versus simply just liquidating the property and taking their, funds from the sale or the proceeds from the sale and just walking away and not having to deal with the property anymore at that point.
I think one of the things that's interesting in that idea is that one of the risks to a seller in a subject to transaction is the credit risk, is the issue that, well, maybe this buyer ends up not making all the payments and I'm still on this loan and my credit is going to be the one that takes a bath on this if things go south. In the probate context where the seller's deceased or the person that's on that loan that you're taking it subject to is deceased, we don't really care about the credit anymore, do we? I mean, the heirs don't really have that risk. That's not gonna hurt their credit, and because they're not changing who's on the loan, so I think that's kind of interesting because that really removes one of the I think that one of the big factors that a seller might say no to a subject to transaction, if you remove that, you remove a big risk factor, I think.
Absolutely. And that is a selling point, which is, hey, if we do this normally, you personally have maybe some exposure, your credit's on the hook. But in this case, there's really no real exposure or damage to credit if the payments aren't made because it's the deceased person's credit that's, was pledged, and they're deceased. They don't need credit anymore. So, there's that risk is definitely mitigated and not a concern.
Yeah, very, very cool. All right, a few update items for you, the listener. Starting in July, we are rolling out again in its full glory the Creative Finance Collective. And we've been talking about this. In fact, we shot kind of a premiere episode with Alan Seshker, one of the premier rap attorneys out of Texas, to kind of feel and see what this would be like. But the Creative Finance Collective is just that, a collection of professionals and attorneys that are in the space of creative finance from all over the country that are getting together to talk about all things creative finance and really talk about this at a much higher level, um, in a much higher level way that you, the listener, might be used to or accustomed to in a YouTube type stream or video. We're not presenting an outline. We're not presenting a how-to. No, this is actually lawyers saying, "Hey, what are you doing on this? Here's what I'm doing on this. Are there ways to do it better? Here's what I'm seeing in my state. Here's issues that I've run into." This is really high-level stuff. But what it provides for you, the listener, is an opportunity to listen, to watch, but to engage, interact, and ask questions and be a part of the conversation on how to learn creative finance and how to grow it. We think it's a really neat opportunity of bringing together some of the best minds in the space on it and provide you the opportunity to engage and interact with it. We are starting that again in July. July 5th will be the first one, but it's going to be every Wednesday at 5:00 p.m. Arizona time. So you get off work, you just want to sit casually and listen, ask questions. You're going to have the opportunity to do so. And there's going to be a variety of members and guests that appear on any given week. Some you might see multiple weeks, some you might see every once in a while, but you're going to get a real diversity of opinion and approaches to creative finance. We really think it's going to be an interesting opportunity. Sean, did you want to add anything to that?
Yeah. So one of the biggest takeaways from our kind of initial rollout with Alan Seshker was I actually discovered, I think it's more about the attorneys and the benefit for the attorneys than for the listeners. And what I mean by that is Yes, the listeners can be there, and they should, and hear what the attorneys are discussing. But um, during our discussion, I learned so much talking with Alan, and Alan indicated that he learned a lot from talking with us. And both Alan and I were like, oh, yeah, I know what I'm doing tomorrow, which is I'm going back and I'm making adjustments to my documents based upon what we discussed today. And Alan indicated the same thing. And so, it's one of those things where, yes, the listeners can sit there and listen to attorneys have these high level conversations. They can jump in with questions. But for me, what I'm most excited about it is the benefit that it's going to have to the attorneys who are there able to discuss these high level topics. I don't have that opportunity very often. Around our office, we have attorneys that understand this stuff quite a bit. And so, we have some interesting discussions maybe around the office, but, outside of that, there's really, at least here in Arizona, there's no group of attorneys that do creative finance that, gather together on a regular basis to discuss it or have, CLEs or anything like that. So this is really the chance for attorneys to network with each other and find out what, the other attorneys are doing and how they can better themselves. So really, I think the individuals that are going to receive the biggest benefit of the collective are the attorneys. And what that means is the audience then gets to see that in real time.
Yeah, 100%. And what I don't think non-lawyers appreciate is what the practice of law is, and it's a practice. It's a lifetime, really no different than medicine, a lifetime of working within an industry and getting better at your craft. And the law is an evolving thing. Every day, court cases come down and change the dynamic of any given legal element or legal situation. So it's not like this thing that you learn one time and that's how it goes, but it really is an opportunity to grow, and an opportunity, the first of kind of its kind. I don't think I've even seen anything like this where collaboratively lawyers who in other ways compete with each in a space are getting together and saying, how can we grow and learn and make things better for not only us, but the client, the investor, and all involved. It's kind of really an all ships rise with the tide thing. All right, with that, so make sure to be with us every Wednesday at 5 o'clock to Creative Finance Collective. It's going to be super relaxed. There's not going to be, introductions and starts. You're going to be coming into a conversation and you're going to be leaving outside of a conversation and you'll be part of it. So we're excited to bring that to you. So let's get into our topic today. Today, we're talking about clearing common clouds on title or title issues. We've all had them, a common problem. This is why whenever you're doing a real estate transaction, you probably should be using a title company. If you are not in a state that customarily uses, or all states are going to use title companies, but if you're using a state where you've got lawyers that are helping close deals, you're using them. You're getting title reports so you can discover these issues. And so you're not stuck with these issues because, as we know, as real estate owners, or what we should know is you can inherit problems when you take over real estate. So part of this problem is identifying these clouds on title and knowing how to resolve them. And by the way, some of them can't be resolved quickly, but this episode is about how to identify those and how do we clear some of those title problems and determine resolutions for those. So let's get right into it. And Sean, let's kind of take these step by step and the different ones that we've experienced and seen and what we've done to, as attorneys, try to fix these issues. And one common one that we see more often than we would like to see, but they come up, are unreleased deeds of trust or mortgages, depending on what state that you are in. So you've sold the property, you've sold it, or you bought the property rather, and the person who sold it before received the payoff. That mortgage company was paid, but they failed to release their lien. Now the viewer that hears that is probably thinking, okay, how is that even possible? How does that even happen? How can a title company let that happen? Sean, why don't you explain that process and give some context as to, one, how does that happen? How do we see that happen in Arizona? And then what are the steps we have to take to fix that?
So one common scenario, like you said, is the loan payoff is delivered to the title company. Title company delivers it to the lender. It's a traditional lender, and they receive it and they don't do anything with it. They just accept the money and show the loan is being paid, but they don't record the deed of release and reconveyance. So it happens a number of ways. Number one, remember these servicers are large and they're servicing hundreds of thousands of loans at any given time. And some of them have better procedures than others in place. And, if you've tried to work with these servicers during the short sale time period, you're going to know some of them are better than others. There are some servicers who you would send in your short sale packet and you would call a few days later. Did you get? Nope. So you resend it. And you do that about 10 times. Others, you'll send it in and you'll call and say, hey, did you receive it? And they're like, oh yeah, we received it. Well, it's the same concept with the deed of release and reconveyance. The money goes, and then somewhere along the lines, there's a break in the chain of command or the chain of tasks, and a deed of release just doesn't get recorded. Other times, it could be that they're in the process of a servicing change because, these notes are bought and sold on the open market, and you could have a servicer for a year, and then you get a new servicer, and then you have that service for a year or two, and then you get a new servicer. Well, it could be that the payoff was delivered like right in the middle of that change. And so, of course, who's going to release? The new servicer or the old servicer? And one thinks maybe one's doing it and the other thinks someone else is doing it. The old servicer, they may not want to waste the time releasing it because we're not getting paid anymore. Our job is done. But then the new servicer may not release because they're saying, well, we didn't get the money. The old servicer got the money, and so we got a zero balance loan. Like, why are we going to do it? We're not getting paid either, right? And so nobody wants to deal with it. So bottom line is the loan's been paid, but you have a deed of trust out there that's still showing a record. And so when you go to sell the property, what do? You open escrow, and the title company runs a title report or a commitment for title insurance. And on that, it's going to show, hey, there's this deed of trust out there that's not been released. And so then you say, well, wait a minute, that was paid off and I have proof. Well, unfortunately, it's not just that simple, right? So there's a couple of options available to resolving that specific scenario, which, like you said, happens more too common than we would hope.
Well, and I think it's important to note too that I think a lot of people think that maybe they wouldn't be familiar with this term, but like a condition to close. The lender recording a deed of release and reconveyance in the context of a deed of trust is not like a condition to close that they do it right then before closing, like that it's recorded. Obviously, it is a condition that they do that and they're required to do that, but they've got time to do that, right? And that's a little bit part of the problem.
Yeah. So what happens is on an escrow. So let's say you have a loan with a deed of trust or a mortgage that you do owe money on. So the way it works is you open escrow, and then the title company or the closing attorney goes to the lender and says, or the servicer for that loan, and says, hey, what's the payoff? How much is that? And the lender and the servicer submits the payoff to the title company or the closing attorney, and they get that payoff. And it says, hey, if you pay us in the next generally 30 days or 14 days or whatever date they put on the payoff, this is the amount that you need to deliver to us. And we're going to call that good. And the loan will be deemed paid in full. And then, so what title does is they, by law, have a right to rely upon that payoff. That's a valid document that they can rely upon. And so title goes and they close and they cut a check to the lender or the servicer for that amount. And when that amount is received by the lender or servicer, by law, both federal and state law here in Arizona, the lender has 30 days to execute and record. So it's incumbent upon the lender. It's not incumbent upon the buyer, the seller, or the title company. It's the lender's responsibility by law to record what's called a deed of release and reconveyance, which basically says we release our lien or our interest in the real estate. And so they then record that, and they have 30 days to do it. Well, what happens if, like I said, in those 30 days, servicing transfers? Well, who's then going to record it? I don't know. Or there's a break in the chain of tasks, or somebody leaves. It could be somebody's like, hey, I'm out, like I found another job. And so, that was one of the people responsible for recording these deeds of release. And then it just is lost in the shuffle between, one employee leaving and another employee taking over, right? It could be as that simple. It's not nefarious. They're not purposely not releasing. It's just some breakdown somewhere. And, these are large servicers with hundreds, if not thousands of employees. And, they're doing a high volume. And so, yeah, it's just a breakdown there. And something happens. And so to your point, yes. So what happens is they don't record within those 30 days. 5 years goes by. And then all of a sudden it's like, oh, I'm ready to sell this property. And you go and you open escrow, and the title company runs their report, and they say, oh, well, this loan is still showing a record. You're like, wait a minute, I paid that off. So there's a few options there when that scenario happens. So the first is, if you closed with a title company or a closing attorney and you obtain title insurance, you have the ability to, at least here in Arizona, go back to that title insurance company and be like, hey, and the title company, and say, hey, look, I closed, you sent the money, the deed of trust wasn't released. It's still showing of record. And they have the right under our statutes, at least here in Arizona, to send a notice to the lender and say, hey, lender, you did not release your deed of trust. And now the loan balance has to be below, I think it's 2 million. So assuming it's below 2 million, the title company can send this letter and say, hey, look, we saw that you haven't released your deed of trust. We paid you. And so unless we hear from you in 30 days, we're going to go ahead and release it. But you have to wait 30 days. And the title company has to be willing to do it. They're not obligated to do it. And so they may be like, well, we already got paid, you didn't bring your escrow back to us. Like, why are we going to go and send this letter off? And it's their choice to do it. So you have to convince the title company that that's what they should be doing. So that's one option. The second option is basically you, as the seller, need to figure out how you're going to get that released. And so there's a process with going about that. So what we do in our office when this scenario happens, we rely upon Arizona state law. Now, there are some federal laws and there's other states that have similar laws. But in Arizona, we have 2 time periods that I utilize when I send this letter out to the servicer of the loan saying, hey, you didn't release, you need to release. So the first is there's a statute in Arizona that says if you provide a written demand to a lender who failed to release their deed of trust or mortgage, and they failed to do so within 30 days, then they're subject to statutory damages. So I always say, hey, look, this was released. You failed to release it within 30 days. This is our written demand pursuant to this statute. You have 30 days to release it or suffer the consequences. So that's number one. The second thing that I do is I accelerate the time frame, though, because 30 days is too long. Your schedule. So like, why do you want to wait 30 days? So the second time period that I rely upon is our payoff time period in Arizona. And the federal statute for federally insured lender payoffs is I think 15 days. So ours in Arizona is 14 days. So we're like a day shorter. And basically what I do is I say, okay, not only have you not released and you have 30 days to release or suffer those consequences, but since your deed of trust is and mortgage is still showing of record, then you are obligated by law in Arizona to give me a payoff. And so I want that payoff in the 14-day time period. And if you don't provide that, then there's also statutory damages for failing to provide that payoff within that 14-day period. And once again, if you don't provide it in that 14-day period, suffer the consequences. So now I've accelerated that 30-day period down to 14 days. Now, what if they come back and give me a payoff? Well, look, if they were paid off, by law, they can't come back and give me a payoff anything other than $0. Now, if they come back and give me a payoff for $0, I give that to the title company or the escrow agent. We will accept a payoff, right? We already, lender says the payoff amount is, then they accept transaction. And so basically we get the time period down to 14 days. It's not that simple though, because normally there's a reason why there hasn't been a release, like a servicing transfer, or sometimes, the servicer, I've had it where the servicer's gone bankrupt. They're out of business. They're no longer operating. So there's a few options that we pursue there. So one is the FDIC. If a servicer goes under, you can approach the FDIC and say, hey, look, because normally before they go bankrupt and a receiver's been appointed by the FDIC. And so I can go to the FDIC and say, hey, you took over as receiver. You were involved in the bankruptcy. Can you give me a release? And sometimes they will. Or alternatively, I've gone to MERS, mortgage electronic registration systems, which basically is kind of a clearinghouse for when loans are bought and sold. And so MERS is listed as the beneficiary of the deed of trust or the borrower under a mortgage. So you can go to MERS and say, hey, look, I need a payoff. You're the beneficiary. You're the borrower under the mortgage, not the borrower, the lender under the mortgage. And statutorily, they have to provide me with the payoff. They can't say, oh, well, we're not. They try to say that, but no, you can't do that. So I normally can work with them to either get the release or get the payoff within 14 days. So there's things that we can do to expedite and have that release. Now, final thing on this topic, and then we can move on to some others. But the final thing here that is what happens if they blow me off? They are like, nope, we're not going to respond. We're not going to listen to you. Or what if they're under, they've completely gone under, and I simply cannot find anybody. Like there's nobody. FDIC can't help me. MERS can't help me. Nobody. I've had those cases where it's like, they're just gone. Like the servicer's gone. Nobody's taking responsibility for this loan, but I have proof that it's been paid off, right? I have a settlement statement showing that, and a check showing it's been paid off. What do we do in that case? In that case, Arizona has a statute that basically states that I can go into court and file an expedited order to show cause, an application for order to show cause along with a complaint. And if I can show that the servicer or the lender is not located in Maricopa County, if that's where the property is located, or whatever county the property is located, that they cannot be located, or they're no longer in business, or if they're an individual, they're deceased. If I can show that and I can provide the court with proof that the loan's been paid off, I do not even have to serve the complaint. The court can execute an order or a judgment right then and there, releasing the deed of trust as a matter of law, ex parte. So ex parte means without notice to the other side, without serving it, without doing anything. They will release it on an expedited basis. So I've been able to where, hey, I just simply cannot find somebody to take responsibility of this and who can actually release it. I've actually been able to go into court, file a complaint, and within a matter of 3 or 4 days have the deed of trust released by the court.
That's what I was going to ask. Was how long do you think that typically takes? Do you think you can do that in sounds like under 5 days?
Oh yeah, I've done it in under 5 days. Now, not every judge is going to fully appreciate or understand this, and you hope you get a judge that has a little bit of real estate background. Other judges have set hearings, said, well, I'm not going to do it ex parte, but I'm going to set a hearing and send it out to whoever, you think might, be responsible, or whatever addresses you have. And then that's going to take, 15 to 30 days. And then you have to go to a hearing. Of course, no one shows up, and then they say, okay, we'll release it. So it just depends on the judge, but by statute, there is a procedure that allows for that ex parte release.
Very interesting. All right, so let's move on to other forms of clouds on title. A real common one, and I think an interesting one in any state, is recorded judgments. I think this is a particularly interesting topic here in our state of Arizona, because we've had pretty substantial recent changes to Arizona's homestead law. So let's talk about recorded judgments, the liens that they create, the clouds that they create, the process of removing them, and maybe the process of when they don't need to be removed given the homestead exemption laws. What does that look like?
So if a judgment is given just for money damages, and it does not create any type of lien or constructive trust or otherwise against real estate, it does not specifically list, the judgment attaching to real estate within the judgment, and it's just a money damage judgment, you didn't pay a credit card, or there's a lender or something out there that, you ended up being sued for an unsecured debt, and a judgment's entered against you. That lender then can record that judgment in any county where you own property, or they think that you may at some point, or you may own property, but maybe they can't find it, they can't identify it. They can record that judgment. And that judgment, at least here in Arizona, acts as a lien on any non-exempt. So that's an important term, non-exempt real estate that the judgment debtor holds within that county. They don't need to identify a specific property. It acts as a blanket lien against any real estate within the county that's not exempt, that's held by the judgment debtor. Now, in Arizona, and most states have them, we have homestead laws, homestead exemption laws. And in Arizona, you're allowed one homestead. So one piece of real estate that you reside in, and that's held in your name, or in a like a revocable living trust, like you've put it into a trust for estate planning purposes. So it's in your name, or in the name of a trust. Holding in an LLC doesn't qualify. It has to be in an individual's name, or a revocable trust for which the individual is the grantor and trustee and beneficiary, etc. You have one homestead, and it is now up to $400,000. Andy, you know this. It was at $150,000 forever. I mean,
for as long as I was a lawyer, it felt like
me
that
too.
was just always the rule.
Yeah, that was it. I mean, and it never changed.
No, nobody ever really questioned it.
No. And then about 2 years ago, it goes up to $250,000. Well, that wasn't good enough. And our voters here in Arizona, like a year later, so it hadn't even been like a year later, they raise it to $400,000. So now it's gone within about a 2-year period from $150,000 to $400,000. So it's a lot. That's a substantial amount of equity that you can have in that property and put in your pocket without having to pay your judgment creditors.
Yeah, and to be clear, you just said it, but it's worth saying it again. We're talking about equity here,
right?
Not talking about the end price of the home. We're talking about equity.
Correct.
That is a lot of money.
Right. So, you have a property worth $800,000 and a $400,000 loan against it. And you get to put all those proceeds in your pocket. You get to put $400,000. So you sell it for $800,000, you pay off the $400,000 loan, and you put $400,000 in your pocket, free and clear of claims of your judgment creditors. Yeah, that's a lot. Now, however, our legislature giveth and our legislature taketh. So they've increased, but they also made it much more restrictive. So when it was 150, the law provided that the judgment didn't even attach to the homestead property. Like it didn't even attach. It wasn't a lien or anything. It would only be applicable if there were proceeds from a sale that exceeded the 150. So it basically essentially attached to the proceeds, but it didn't attach to the real estate, which means what you could do is you could refinance that property and pull cash out and not have to pay the judgment. So if you had a house that was worth 800,000, you owe 200, but you're like, oh shoot, I have a judgment against me and I want to make sure I'm within that, homestead. You could go and refinance and pull, generally up to 80% of the value of the home out in cash, put it in your pocket, then sell it, get your $150,000 homestead and, pay the creditor nothing.
Yeah, and all the title company had to do along the way is really just confirm that we're talking about homestead property.
Yeah, they just would ask the borrower to sign an affidavit confirming that it was their homestead, and they would close the transaction. And the borrower could pull cash out. Well, of course, now our legislature said, no. It's a lien. It's a lien against the real estate. However, a licensed title company or escrow agent, so licensed with the Department of Financial Institutions here in Arizona, is authorized to record a release of that lien if they sell the property and the amount that's going to be of proceeds is not going to exceed, well, I don't want to get too far in the weeds, but they can automatically record the release of the lien if the amount of the proceeds is less than 80% of the homestead amount. If it's greater than 80%, then they have to send notices to the creditor and wait for them to respond. And assuming they don't respond, then they can record the release of the lien. But the significance is there is now a lien against the property and there are no cash out refinances. So the minute that judgment is recorded, you're locked in. Whatever those loans against the property were at that time is what exists. You can't later go and refinance and pull cash out because the judgment is now effectively a lien against the homestead, except that licensed title companies can release the lien as long as you're not receiving more than the homestead from the sale of the property.
Very interesting.
Now, one thing that when it comes to real estate investing and subject to transactions that does in Arizona is it creates potentially a problem where an investor, for one reason or the other, wants to self-perform, what they call self-perform the closing, which means they close outside of escrow. They look at the property and they say, oh, okay, you owe 500,000. I'm going to take over your loan subject to, I'm going to close, but maybe for one reason or the other, there's maybe an FHA or VA loan, which a lot of title companies don't like to close. So they're like, we're going to self-perform. So they go and they self-perform, but there's a judgment out there, and which normally would not be a big deal because the property's homestead, so the seller's like, don't worry about it. The property's homestead. The judgment doesn't attach, and, I'm not receiving really any equity in the property to speak of. So it's not a big deal. Let's just, close. Well, wait a minute. You can't do that now, because before you could, because the judgment never attached. But now, because it's a lien, you have to close. If you have a judgment against you and it's a homestead, you cannot self-perform a closing. You have to close through a licensed title company, because the only way to get that judgment released is through a licensed title company by law, by statute. And so, you cannot close outside or self-perform. You have to now close through a licensed title company if you have a judgment and you're trying to close on a homestead property.
And on top of that, how do you even know if there is a recorded judgment without having used a title company? Like,
Now, for self-performing, what you do normally on a self-perform closing is you would go and purchase from a title company a condition of title report, and then they would deliver that to you. But you're not getting title insurance, and there's no what we call abstract liability. So, like, it's as good as the paper it's written on, but at least somebody with experience has run a report and told you, what the status of title was. And then you would see the judgment and then say, oh, well, it's not a big deal. Let's just close because it's, homestead. Well, no, it doesn't work that way anymore.
interesting. Yeah, big changes to Arizona law, and that, like you said, has implications just not only for just the average buyer, but the Subto buyer who's doing it, who, like you said, wants to perform. Let's move to another one we commonly see in generic transactions or even Subto deals are, you find a deal, this property looks great. You think it's gonna be a quick and easy close, and you find out there's deceased individuals on title to the property. Maybe that's multiple individuals, maybe that's just grandma passed away and, they're trying to move the property, but there is, there's a deceased person on the property who's there not able to sign at the closing table. So what do we do to fix that issue?
Yeah. So that's another common one where we see that, and what happens is, unfortunately, instead of going to attorneys and saying, hey, look, I need to create an estate plan, families decide that they're going to kind of do their own estate planning, and they're going to pass property down amongst themselves by doing quit claim deeds and warranty deeds that they prepare themselves, and they record, and it results in what they think is, hey, the grandkids now own the property, and then you realize, well, wait a minute, like, that's not how it worked. And now you have, an aunt and uncle, a grandparent that's still on title because the deed wasn't done right, wasn't properly executed, whatever. And they're deceased, and now we need to deal with their estate. So what does that look like? Sometimes it can be simple. So in Arizona, we have an affidavit of succession to real property, which provides, and correct me if I'm wrong, Andy, because I know you know this as well, but I think it's if the equity of the property or that person's equitable equity interest in the property is not greater, is less than 100,000.
I believe that's still right. Yeah.
Yeah. If for example, if grandma who's still on title, if let's say she still owns a quarter of the property, and the property is owned free and clear, and it's worth 200,000, or the assessed value is 200,000, then we could do an affidavit of succession because grandma's interest is only worth $50,000. And so it would be as simple as the grandma's heirs, whoever's entitled to inherit from grandmother's estate, fill out and execute an affidavit of succession to real property. It gets filed with the probate court. The probate registrar looks at it, and if everything's on the up and up, then they certify it. And then a certified copy of that is delivered to the title company. And then the title company closes, and then grandma's heirs execute whatever deeds that they need to execute to the end buyer. And then the transaction closes. It could be as simple as that. Or it could be that, no, the value of grandma's interest is greater than the 100,000. And so at that point, we have to do an informal probate, which means that we have to find somebody that's going to be appointed or the next in line, according to either, if grandma had a will, it'd be according to the will, or it'd be according to our statutes. We would figure out, hey, who's the proper personal representative for grandmother's estate, and have them appointed in an informal probate proceeding, which that can actually be done fairly quick. It's more expensive than the affidavit of succession, but it could also be done pretty quick. We prepare the documents, assuming that the personal representatives, Johnny on the spot, they sign everything. We file it with the registrar considers it, and they're appointed. We can do that in about a week and a half. It's fairly quick. And then once a person's appointed, then they can execute whatever deeds they need to convey grandma's interest to, the rightful heirs, who then convey it to the end buyer or directly to the end buyer, depending on exactly how they're going to structure that. And that's taken care of. Now, where things really get complicated is if we don't have anybody who can serve, or we can identify a ready, willing, and able personal representative. And in that case, we're going to have to do a formal probate, which means that we're going to have to file with the court a packet. The court is, there's going to be a judge or a commissioner assigned. They're in charge. They're going to set a hearing. That hearing is going to be set out generally 30 to 60 days because they have a busy calendar. And then we go to the hearing and we explain the person that we want to have appointed and why, because they're not within the list of, succession for PR purposes, or they're not in the will. And so we have to explain why this person should be appointed. We have to give notices to other, interested parties, and then hopefully they'll be appointed. And then of course the court will oversee that probate to its conclusion, and there's more work. So it's, costly, it's time consuming, but it can happen. It's just going to take time. And then once that PR is appointed, once again, they can execute whatever deeds they need to, close the transaction. So yeah, somebody ending up on title. It's never the greatest thing, and it can hold up escrow, or maybe we can close, quickly. But it just has to be dealt with. And there's processes, at least here in Arizona, in place to handle it. The one thing in going through these three different types of title issues, the one thing I do want to say and impress on our listeners, and this is, very important to know whether you're here in Arizona or otherwise. And, our firm does a lot of this title work, clearing titles. We've seen a lot of things over the years. And so we know what, the different ins and outs. And the one thing I always tell my clients, and I'm going to tell the listeners, is generally there's no title issue that cannot be resolved. It's always just a matter of time and money. Do you have the time that it's going to take? And do you have the money that it may take to get it resolved? But it can get resolved. I've honestly never seen a title issue where I'm like, oh no, we can't figure that out. Like, that's impossible. No, it can be resolved. It's just, sometimes it's going to take a week. Sometimes I've had them take 2 years because there's so many steps involved, and we had to complete one step before we could move on to another. And we eventually completed it. And they closed escrow, and, our client was happy as they could be, and they were patient, and we did it, but it took time and it took money. So, title issues are not impossible. They can be accomplished, but it's just a matter of time and money.
Yeah, believe it or not, the law supports generally a free, open, and marketable title. It wants you to be able to move your property and do what you want with your property. But sometimes that involves the courts. And whenever you involve the courts, that involves things like due process. And like Sean said, that's time, that's money with a lawyer, and that's just the bottom line, but it will get done. All right, with everybody, that is our episode for this week. Make sure to join us next week for our next episode. Make sure to be prepared for the July 5th Creative Finance Collective to be a part of that. We'll see you all next week.
Have a good day, everyone.